morning, ladies and gentlemen, and welcome to ACCA F4 Foundation for Corporate and Business Law. This morning we're going to have a 45-minute session which is part of our series on employment law. In particular, we're going to look at the following topics today. We're going to look at the relationship that an entity has with an employee and defining the difference in the working relationship between an employee and a self-employed independent contractor. So part one, we're going to look at the types of working relationships in the UK, whether a person is defined as an employee or a self-employed independent contractor. Secondly, as part of this, we're going to look at the ways the court tests whether an individual is an employee or a self-employed contractor. So the court looks at three different types of tests, which we're going to talk about quite soon. Thirdly, we're going to look at difficulties in applying these tests. So why it's not always easy to tell whether an individual is an employee or a self-employed individual contractor. Finally, we're going to look at the reasons for the distinction between one type or the other type of working relationship. So why the court will make a difference and why there are certain differences in the treatments between one and the other type of working relationship. So I'm going to ask you to stay with me because we're going to have a quiz at the end of this, and you're going to need to respond to the questions that I ask you. So stay with me for 45 minutes and we're all going to learn some interesting things. So, first of all, let's look at the nature of the working relationship in the UK. There are two fundamental types of working relationship. The first of which is the more usual, which is an employee-employer relationship. Now, what is the relationship that you have with the company you work with? You're all Big Four employees of a Big Four firm. Are you employees of this firm? Correct. You are trainees of the Big Four firm that you work with, and you are also employees. And again, this is the more normal type of working relationship. You work under a contract of service, and you have duties and obligations which arise from that contract of service. However, there is a second type of working relationship which is more unusual, and this is a self-employed independent contractor. Now, these people work under a contract for service, and there are some industries where this is more common. Can anyone give an example of industries where self-employed independent contractors are more common? That's right. Historically in the IT industry, self-employed independent contractors are used instead of employees because there are certain advantages and disadvantages to this type of relationship as well. So, to quickly summarize, in the UK we have two specific types of working relationships. We have employees who work under a contract of service, and we have self-employed independent contractors who work under a contract for service. And the type of relationship that a person has isn't necessarily a cut and dried thing. Sometimes a court will apply tests to see whether a person is one type or the other type. And there are three tests that the court in the UK that the court will apply. And these tests have evolved over time from the most primitive, which is the first one, the control test, through to the integration test, and which finally onto the most evolved and most sophisticated test, which is the economic reality or multiple test. So the court will test the nature of the working relationship using these three tests to see whether a person is an employee or a self-employed independent contractor. So let's take a look at the detail of these tests. And the control test, as I mentioned, is the oldest test, and this goes back to 1880. The case law of this on this one is Ewens versus Noakes. And the control test is the court will look at whether, how, where, and when the employee works and who controls that. If the company controls it, then it would support the perspective that the individual is an employee. If the individual controls how, where, and when they work, then it will support the view that they are an independent contractor. And let's look at the specific case on this. First of all, Ewens versus Noakes revolves around the definition of the word servant, because it's an older case, but it has come to define the meaning of an employee also. So it's part of the case law on that. But applying the particular case law, let's look at Walker versus Crystal Palace Football Club, which is a 1910 case. And Walker was a professional footballer who worked with Crystal Palace Football Club. And the case revolved around whether, part of the case was whether Walker was an employee or a self-employed independent contractor. And here the court looked at the specific facts of the relationship, in particular applying the control test. And it decided that although on the football field he did his own thing in terms of scoring goals or saving goals or attacking or defending or whatever his particular role on the field was, that the company was in control in relation to things like training, discipline, and method of pay. So looking at the facts or applying the control test, the court decided that Walker was an employee of Crystal Palace Football Club and not an independent contractor. So that's the case law in the application of the control test. When we talk about more modern types of employee-employer relationship, employees in general have become more skilled with the advancement of technology, and there are times where the control test is not really applicable in a modern setting, because modern employees can be more skilled, and sometimes, quite a lot of the time, they know more than their bosses on the specific area in which they are experts. If you look at people like chemical engineers or even accountants, accountants may know more than the people they report to or the people who give them direction. So the control test in itself, as the working place has evolved, has become just a subset of what the court will look at. So let's look at another test, which is a more recent test. Let's take a look at the integration test. And again, the court will apply this integration test to determine whether an individual is an employee or a self-employed independent contractor. And the integration test tests whether an employee, if their work is an integral part of the business, if they are part and parcel of the business and not merely an accessory to it. So if an individual is part and parcel of the business, they are well integrated into the business, which means they are or tend to be viewed by the court as an employee. If they are merely an accessory and they come in to perform one particular role, they tend to be viewed by the court as an independent contractor. So let's take a look at the case law on this. And here we have the Whittaker versus the Minister of Pensions, which is a 1966 case. And the facts of this case are that Whittaker was an independent contractor. Whittaker was, Whittaker was a trapeze artist. And in the course of performing her act, she injured her wrist. And the specific details of this case was the court needed to decide whether she was an employee or an independent contractor to see whether she could benefit from industrial injury benefit as an employee, which she would not benefit from as an independent contractor. So, looking at the specific details of this case, it was held that Whitaker performed, in addition to her duties as a trapeze artist, which meant that she just came and performed her act, she performed other general tasks while working with the circus. So she might have done things like working in the box office, doing cleaning at the circus, training of animals, and so on. So she performed other general duties while working with the circus. So looking at the integration test, the court decided that she was an integral part of the circus and not merely an accessory. So as an integral part of the circus, she was an employee and not merely an accessory. So there you can see the application of the integration test as applies to the specifics of an individual case. Now, it's important to understand that a limitation of the case of the integration test is that it is difficult to apply as the sole criterion. So the integration test is, in modern day thinking, not in itself sufficient, which brings us to another evolution of the testing of the employee, self-employed, independent contractor relationship, or the working relationship. Brings us to the third test, which is the control test, or, I'm sorry, not the control test, the economic reality test, or the multiple test. So, looking at the economic reality test, it's a much more sophisticated test than the previous two tests. And it also integrates the control test. So the court takes a much broader range of factors in view when it looks at testing the employee or self-employed independent contractor, the nature of the working relationship. It looks at the control test, so it applies the control test, but it also applies other factors in testing the nature of the relationship. For example, it applies equipment test, or the equipment factor, and it looks at, does the employee provide his or her own equipment at work? So does the employee provide their clothes? Does the employee bring a laptop to work? Does the employee use their own vehicle, a car or a truck? Does the employee bring their own tools, a hammer and chisel and saw, that type of thing? So who provides the equipment that the employee or individual working performs their duties? So there we have an example of the court applying the equipment factor. And if an employee does not provide their own equipment, if the entity with which they have a relationship provides the equipment, then that would tend to support the perspective that the individual is an employee. If the individual provides their own equipment, then that supports the perspective that the individual is a self-employed independent contractor. So if you bring your own laptop to work, if you wear your own clothes, for example, a suit to work like you do, if you bring your own truck, or you drive your own car and you bring that to work and you use it in the course of your working duties, then that supports the view that you're an independent contractor. Thirdly, with regard to helpers, if you hire your own helpers to aid you in the performance of your own work, then that supports the view that you are an individual contractor or an independent contractor. If you assume a measure of risk in the relationship that you have with the entity which you have a working relationship, then that supports the view that you are an independent contractor. If you have a significant degree of responsibility for investment and management, then that supports the view that you are an independent contractor. If you have no responsibility for management, and if you have no responsibility for investment, then that supports the view that you are a normal employee. If you partake in the profits from the working relationship, from sound management in the performance of the tasks, then that supports the view that you're an independent contractor. If you don't take a share of the profits and benefit from sound management, then that supports the view that you are an employee. The court may also look at payment. So if there is a regular means of payment, that supports the view that the individual, or you, is an employee. If there are no regular payments, then that supports the view that you are a self-employed independent contractor. Also with regard to hours, if there are regular hours, then that supports the view the individual is an employee. If there are not regular hours, then that supports the view that the individual is an independent contractor. Finally, with regard to obligation, if there is a mutuality of obligation between the entity and the individual, by entity I mean it can be another individual employing that individual, or a company, different forms of company employing that individual, or having a working relationship with that individual. If there is a mutuality of obligation between the individual and the entity that employs it and the individual, that supports the view that there is an employee-employer relationship. If there is no mutuality of obligation, then that supports the view that you have an independent contractor. Now, mutuality of obligation means, is the company obliged to provide work, and is the employee obliged to do the work? If you have a self-employed independent contractor and a relationship with an entity, there is not that obligation to, on behalf of the entity, to provide the work, and on behalf of the individual to perform the work. So there is no mutuality of obligation. Okay, it's important to understand, and we're going to look at the case law on this in a moment, that the economic reality test is not an exhaustive list. So the court will look at a very broad range of factors, and even broader than the list that you see here. But this is a good indicative list. And let's look at the specific case laws on this. First of all, let's look at Ready Mix Concrete Limited, which is a 1968 case. And Ready Mix Concrete, here we have the driver of a truck who had a working relationship with the company. And the specific facts of this case are tested by the court in applying the economic reality test. So the court looked at we'll see the individual factors that the court looked at. So for example, this driver drove the lorry only on the company business. He obeyed the instructions of the foreman. He wore company colors. He provided his own lorry. However, this truck had been leased from the company, and the driver paid the company for the truck. The truck was painted in the company colors. He could employ a substitute driver. In other words, someone else could do the actual driving. He was paid on the basis of mileage and quantity of goods delivered, and the driver paid his own expenses of repair and maintenance. He also paid his own national insurance and income tax, which we're going to talk about a little bit further on. Now, in looking at the facts of this case, the court held that he was an independent contractor, not an employee of Ready Mix Concrete Limited. And the employee exercised some control over his work. The driver owned his own vehicle and operated at his own financial risk to a degree, which supported the perspective that in this case the driver was a self-employed independent contractor. So the results of the test were that the driver was a self-employed independent contractor. Let's look at a different case on this, which is the Market Investigations Limited case, which is another 1968 case. And here we have a market research company who had a working relationship with a market researcher. So this lady did market research on behalf of the market research company. She was a surveyor. And she worked on and off with the company under a series of contracts. And her instructions were issued by the company. so she operated to a measure under the control of the company. She had to complete the work within a specified time, although she did not work specific working hours, and there was no provision for holiday or sick pay in the working relationship which they had. In addition, she was free to work for others. So the court tested the specific facts of the working relationship and held that she was an employee, that she was not in business on her own account. So she was an employee of Market Investigations Limited. And the terms of the contract were consistent with a contract of service. She did not provide her own tools, and she took no risk. So the court held that she was an employee. The court also underlined in this case that the economic reality test, or the multiple test, there's no exhaustive test, there are no strict rules as to all the factors which identified a contract of service. So what we're saying here is that whatever list of factors you might make, it's not necessarily exhaustive. So the court will try to take a broad view of the factors which determine whether the nature of the relationship is employee-employer or a self-employed independent contractor. So the economic reality test is not exhaustive. So the court can take a very broad view of the factors of which it can look at. So that's the application of the economic reality test, which is the most sophisticated test. Now, there are certain difficulties in applying these tests in looking at the specific facts of the situation, especially with regard to two specific types of workers. And the first are temporary and casual workers, and the second are home workers or out workers. Now, temporary and casual workers, you're probably aware of what they do. And let's look at the case law on this, which is O'Kelly versus Trust House Forte, which is a 1983 case. And O'Kelly was a casual worker. Excuse me. And he worked with a banqueting hall, and he was given work when a waiter was required. He worked as a wine waiter, known as a regular casual in their working relationship. And he had no other employment. And again, the court is applying the economic reality test here. So he did not use his equipment. He had no share in profit. He made no investment in the banqueting hall. He wore a company uniform. It was generally accepted that he would be offered work in preference to others, and if work was available for him, that it was generally accepted that he would accept such work where offered. So in that mutuality of obligations, this case hinges. And looking at the specifics of the O'Kelly case, the court held that O'Kelly was an independent contractor. He was not an employee of the banqueting hall. And this case hinged around the mutuality of obligation. There was no mutuality of obligation in this working relationship. And the company was under no obligation to offer O'Kelly work, and O'Kelly was under no obligation to accept it. Although there was an understanding that he would be given work and that he would accept it, the court held, based on the specifics of this case, that there was no mutuality of obligation, and so O'Kelly was a self-employed individual contractor. Looking at a similar case, which is Nethermere, which is a 1984 case. This is a case of home workers or out workers, and the court is applying the economic reality test based on the facts of this case. And the key facets of this case are that the two ladies were out workers who worked at home. There were other factory workers who worked in the factory and performed similar tasks, but these two ladies worked from home, and they sewed trousers. The company brought them the raw materials, and the finished goods were sent back to the factory. The company relied on the output of these two ladies, much as if they were employees working on the shop floor of the factory. And the company provided the machines with which the ladies worked on at home. Excuse me. Now, the companies let the ladies know. The ladies let the company know when to deliver material and when to collect the garments. The two ladies rarely refused work. They gave warning if they did not want it, for example, if they were going to go on holiday, and they submitted timesheets. In addition, they were paid the same rate as the workers working in the factory. The company relied on their production. Now, looking at the specific facts of this case, applying the economic reality test to see whether they were considered to be employees or self-employed independent contractors, by giving and taking work regularly, the two ladies had developed a mutuality of obligation over time. In other words, there was a mutuality of obligation between the company to provide work and the two ladies to perform the work, except when they had decided that they were going to go on holiday. So there was a mutuality of obligation based on the specific facts of this case, and applying the economic reality test and the mutuality of obligation factor within the economic reality test meant that the court was satisfied that the two ladies were employees of the factory. So they were not self-employed independent contractors because there was a mutuality of obligation between the factory and the two ladies. So that's an example of the application of the test, and some of the difficulties in applying the test. In particular, the O'Kelly case looks at the temporary and casual labour, and the Nethermere test looks at home workers or out workers. And you can see that both cases are an example of application of the economic reality test and the specific factor, which is mutuality of obligation, which turns out to be key. So, moving on. Why is there a distinction between employees and self-employed independent contractors in the UK? There are several reasons for the difference between the two. And in particular, employees, the employee-employer working relationship has more protection than a self-employed independent contractor relationship has with an entity. So there's more protection for employees, for example, things like unfair dismissal and redundancy. Employees have statutory protection that self-employed independent contractors don't. So in some ways employees have an edge here. There are also more implied terms in the relationship between employer and employee, and if you take another class in this, you'll see what implied terms actually are. But there are more implied terms in this relationship. So employees have more duties to an employer, and employers have more duties to an employee in an employee-employer relationship than an independent contractor relationship. So this is important to understand. Things like there is a duty of obedience between an employee and employer, which does not exist in a self-employed contractor, independent contractor relationship. Looking at creditor ranking, employees rank higher than self-employed independent contractors when it comes to something like, for example, insolvency. An independent contractor is an ordinary unsecured creditor, whereas an employee is a preferred creditor, which means that on the insolvency of the employer, an employee ranks above a self-employed independent contractor, so they get paid first, and only if there's anything left over will an independent contractor get paid. So in the case of bankruptcy of the employer, an employee is more likely to get paid than an independent contractor. One which I just skipped was vicarious liability. So I'm not going to go into the specifics of torts and liability because I'm going to assume that you covered in other classes, but an employer is liable for the acts of the employee performed in acting in the course of the employer's business, the employee is liable for torts which the employee performs. So if an employee injures someone or something while they're in the act of performing or working with the employer's business, they are vicariously liable for the torts that take place. So for example, let's say you have an employee driving the ice cream truck of an employer. If they knock someone down, the employer is liable for the injury to the person who has been knocked down, although they were knocked down by the employee and not the employer. So the employee is liable through the employer is liable through the employee, or vicariously liable for the torts of the employee. When we look at a self-employed independent contractor, the company is not vicariously liable. So liability does not pass through to the company when we talk about self-employed independent contractors. So if you have a self-employed independent contractor who is, for example, is captain of a boat, and he drives his boat into another boat, then the self-employed independent contractor, vicarious liability does not pass through to the employer for torts committed by an independent contractor. So let's move on to tax. And there's a difference, and this is quite key, because a lot of people choose the independent contractor relationship because there are certain tax benefits. Employees receive their pay net of income tax and national insurance under the PAYE system. So in the UK, under the PAYE system, employees receive their pay net. Self-employed independent contractors receive their pay gross, and they're taxed under the trading income provision. So they receive gross pay and they pay tax later. So employees receive their tax net, and self-employed independent contractors receive their tax gross. With regard to statutory benefits, there's another difference, which are that employees are eligible for things like statutory sick pay. Independent contractors are not eligible for certain state benefits like statutory sick pay, for instance. So another difference between employees and self-employed contractors. So those are some of the reasons for the distinction between one or the other type of working relationship in the UK. So, now I hope you've all been paying attention. We're going to have a quick quiz on the topics that we just discussed, the nature of the working relationship. And first of all, let's look at these three statements, and we're going to decide which of these statements point to the fact that an individual is an employee or a self-employed individual contractor. First of all, is the employee required, if in the nature of the working relationship, that the employee is required to provide his or her own tools? Does that point support the view that they are an independent contractor? If so, raise your hands. Correct. Everyone raised their hands, which points to the view that the individual is an independent contractor because they provide their own tools. So they provide their own truck, they provide their own clothes, they provide their own laptop, provide their own machinery, whatever it happens to be. So if they provide their own tools, it supports the perspective that they're an independent contractor. Let's look at the second one. They're required to carry out the work personally and cannot send a substitute. Does this argue for an employee? Raise your hands if you think that person is likely to be an employee. Correct. It means that they are also likely to be a self-employed independent contractor. Oh, I'm sorry. They're likely to be an employee. So if they cannot bring in a substitute to perform their work for them, then that supports the view that they are an employee. Let's look at the third one, which is the individual is paid in full without the deduction of any income tax. Do you think that person is an employee? Correct. That person is not an employee. They are a self-employed independent contractor because they are paid gross without the deduction of income tax. So that person is a self-employed independent contractor. Okay, let's look at the next one, which is, which of the following statements is incorrect? Employees have a right not to be fairly dismissed, but this does not apply to independent contractors. Is this true or false? Raise your hands if you think it's true. Okay, very good. It is in fact true. So employees cannot be unfairly dismissed. However, by the legal definition, independent contractors can be unfairly dismissed. So that's one distinction. So this statement is true. Let's look at the second one. H must deduct income tax and national insurance contributions from the wages to its employees, but it must not deduct these from the amounts paid to independent contractors. So what we're saying here, is this statement true or false? Correct. This statement is true. So it must deduct tax and national insurance contributions from its employees' wages under PAYE in the UK, but not from the amount paid to independent contractors who are paid gross. Very good. Now, C. Both employees and independent contractors can enforce contractual rights against their employer or the entity with which they have, or individual with which they have a business working relationship. Is this true or false? The answer is yes, it is true. So both employees and self-employed independent contractors have contractual rights in their working relationship. So both have rights, although the specifics of these rights and duties may differ. And we talked a little bit about that, and we're going to go on to if we do another class, we're going to talk a little bit about that. So finally, D. Do employees and self-employed independent contractors rank equally when it comes to an insolvent liquidation? Is this true or false? Raise your hand if you think it's true. Okay, very good. None of you raised your hand because this statement is false. Employees rank higher than self-employed independent contractors because employees are preferred creditors who get paid first, and independent contractors are normal creditors who get paid after the preferred creditors or after the preferential creditors. So employees rank higher than self-employed independent contractors. Very good. Now, one more page. We've got, which of the following is a test that the courts use to determine a worker's status? A, B, C, or D? So raise your hands if you think it's A. Okay, no one raised their hands. Raise your hands if you think it's B. No one raised their hands. Raise your hands if you think it's C. No one raised their hands. Raise your hands if you think it's D. No one raised your hands. Okay. No one raised your hands for any of the options, which is actually incorrect. One of the options is correct, and the answer is B. It is the multiple test, also known as the economic reality test. So that is the test where the court looks at a much broader range of factors than the other two tests. And this range of factors can be non-exhaustive, as we talked about in the case law. So the correct answer is B. The multiple test is the test which, of the list, is a test which the courts use to determine the nature of a working relationship. Okay, on to the second question. Which of the following statements is correct? We talked about vicarious liability. An employer is vicariously liable for the torts of its employees, and an employer is vicariously liable for the torts of self-employed independent contractors. And if you think the first statement is correct, raise your hands. If you think the second statement is correct, raise your hands. If you think both statements are correct, raise your hands. If you think both statements are incorrect, raise your hands. So, very good. Those of you who raise your hands to show that the first statement is correct, the employee is liable only for torts committed in the course of their employment by employees. It is not liable or vicariously liable for the torts that independent contractors committed in the course of their employment or in the course of carrying out their work. So the employee is only vicariously liable in the case of employees. Very good, well done. Now, let's wrap it up, and we're going to have a quick summary of what we talked about. We're talking today about employment law, and in particular we're looking at two distinct types of working relationship. The employee or self-employed independent contractor. And one operates under a contract of service and another operates under a contract for service. So those are two distinct types of working relationships. And the court will look at the facts of the working situation to determine whether an individual is one or the other type. And there are three different tests which have been applied in this regard. There is the control test, where we look at where, when, and how the employee or the individual performs the work. We look at the integration test. We look at how closely that individual is embedded in the business or integrates into the business, and whether that individual is part and parcel of the business. And if that individual is part and parcel of business, that supports the perspective that they are an employee. Finally, we looked at the economic reality on multiple tests, where the court will look at a broad range of factors, including control, in deciding whether that individual is an employee or a self-employed independent contractor. So they will apply a non-exhaustive list of factors in testing the nature of that relationship and putting that relationship under the microscope. So there we have the three types of tests of the employee or self-employed independent contractor relationship. As we've seen, there are some difficulties in applying tests in relation to casual or temporary workers and home workers. So in looking at the case law on this, we've seen that it's not necessarily obvious whether an individual is an employee or a self-employed independent contractor. The court will look at the facts of the case. And in particular, when we look at casual and temporary workers and home workers or out workers, the court is looking at the case law. The court has looked at mutuality of obligation, whether the company is obliged to provide work and whether the individual is obliged to perform it, which would tend to support the view that there is an employee-employer relationship. So that, you could argue, or you could take the view that is somewhat key when it comes to the difficulty in application of the economic reality test, or the employee-employer relationship, and the independent contractor, self-employed individual. So there are certain difficulties in applying tests with regard to casual and temporary workers and home out workers. So, okay, finally, let's summarize the reasons for the distinction between an employee and a self-employed independent contractor. An employee has more protection. There are certain implied terms in the relationship between an employee and employer which don't exist when we talk about an independent contractor. There is vicarious liability. The employer has a vicarious liability for torts performed by committed by an employee in the course of performing his or her employment, or his or her duties with the entity that employs it, or the individual that employs it. So there is vicarious liability in the employee-employer or employer relationship, which does not exist in the case of a self-employed independent contractor. we've seen that employees rank higher, they're preferential creditors, and self-employed independent contractors are normal creditors. So employees rank higher than self-employed independent contractors. In addition, employees are paid net. They operate under the PAYE system, whereas self-employed independent contractors are paid gross, and they do not operate under the PAYE system. And also with regard to benefits, employees are eligible for certain benefits, certain state benefits, which self-employed independent contractors are not eligible for. So those are some of the key distinctions between an employee and a self-employed contractor. Now, does anyone have any questions on the nature of this working relationship? Now would be a good time to ask me any questions that you may have. Okay, very good. Everyone is absolutely clear on the nature of a working relationship, some of the tests that the court applies, some of the difficulties in application, and some of the reasons for the distinction. Very good. Now, if you have any more questions, I'll be available for some time after class, so please feel free to ask me anything you'd like to know a little bit more about. So I'd like to thank you very much for your attention, and I hope you have a good afternoon.